Representative Collier.
Mr. Hendrick, can you finish your statement, please? I'd like to hear the rest of it.
Excuse me. Yes, just was stating that, in the cases where we've heard about furnishing an abortion, that there is some old case law, of course, that maybe suggests that that applies to, actually performing the abortion. What the court said in Fund Texas Choice v. Paxton, what the opinion relied on basically was stating that, first of all, there were two very concrete examples. One, General Paxton's own filing suggested that purchasing a bus ticket for someone to go to New Mexico would be a violation of that furnishing statute. Second, there was a letter drafted by Representative Kane and signed on to by several other members of the House to a law firm here in Austin that had stated that after the laws went into effect that they would provide funding for women who worked for them to go out of state to receive an abortion. They were threatened in the letter with prosecution, 2 to 5 years, which is in fact the criminal penalty. And in a tweet regarding the letter, where the letter was posted, citing to the 1925 law was in fact what they were claiming the violation was by the law firm. I would also note that many of the proponents of the bill here today were at the Senate about 10 days ago testifying in favor of a bill that would criminalize people for providing information about how to get an abortion out of state and criminalizing behavior such as funding people to receive reproductive health care outside of the state. Both of those seem to be going hand in hand here and tying back in this possibility of bringing back the 1925 law, especially as Ms. Zabrowski very articulately explained, there is a pretty simple fix here, which is just to say that all of any Texas statute addressing abortion is covered by this exemption. If the Fifth Circuit were to decide on the merits later down the line that the 1925 law should actually go into effect, well, that definition could still apply as long as the overarching definition of medical emergency in the bill would encapsulate all Texas laws that are in effect addressing abortion.
So it looks like, because I pulled up this Vernon civil statute, and it does reference that the following article was held to have been impliedly repealed in McCorvey versus Hill. And then it says, it goes on to this section 4512.1, 4512.2, 4512.3, 4512.4, 4512.5, and then 4512.6. Now, this bill doesn't reference any of those except for 4512.6. Is it your concern, which is section 14 of this bill on page 8?
I believe those other sections would be addressed by the Chapter 6.5, Title 21 of Vernon Civil Statutes. So it references that one specific citation of the code, but then it also makes reference to the entire chapter in Section 14 of 16.5.
Okay, because it references this chapter.
That's
and the reason
correct.
why they have the definition of medical emergency in Section 14 is because it's a whole new code in a whole different chapter, which medical emergency may not be defined in.
Correct. In fact, the way it's defined currently, which again, doesn't necessarily comport with what I was just saying about the old case law being reimagined, is that there has always been the exception in the 1925 ban, medical advice for the purposes of saving the life of the mother. As far as we're aware, and our research showed, there was no case in which a pre-roll prosecution detection for an abortion that was medically advised under that standard. Like I said, the constitutional and statutory interpretation rules have been refined and changed by the Supreme Court to fit the plain meaning rule more since the 1999 case of Fitzgerald versus Advanced Spine Fixation Systems, Inc. But that being said, I think, there is a reference in there already in the 1925 statute. Again, we could use probably some clarity on that in our modern context, but there's no reason we couldn't put that somewhere else in the code, have it apply to all abortion-related statutes, and therefore, with that reference of, putting it in the health and safety code and then not necessarily specifically referencing the 1925 law. And then it can play out through the courts as it's going to play out now, and it would be covered if the Fifth Circuit decision doesn't necessarily go our way. Our way, meaning the way that the ACLU believes it should go, but and not, of course, everyone here. But you know, by phrasing it that way, by making the construction of the statute that way, I think we close the possibility on opening this Pandora's box of letting the 1925 law. And also not letting that case play out through the courts under the current jurisprudence in which it's playing out through the courts, which is based on the idea that it hasn't been amended and therefore it is nullified via implication.
Okay, so would you, if this was taken out and that other part was added about exception for medical emergency and all abortions, would ACLU change their position on the bill?
I think it would go a long way. I think, there are also some things about fetal anomaly that we've heard today that we would like to see in the bill as well. But I think that is definitely for us the biggest thing that needs to be addressed in this piece of legislation.
Okay, and I just want to make sure we understand, if there's a fetal anomaly with a substantial risk of impairment to bodily function or the risk of death, then under this bill, an abortion would be acceptable.
That's my understanding, but I think the fact that there's a question about that is, again, why I started my comments with pregnancy is very, very often far too complicated to legislate. Because I think you're correct that is the intent of the bill. I think we've also heard from some very powerful witnesses here this morning about how that wouldn't necessarily have helped them in their cases, even though, we all can agree, I think, having heard the stories, that they were in desperate need of care.
All right, thank you.